Welcome back to the Deep Dive. Today, we are effectively taking the training wheels off. We're moving way past the simple A shoots B scenarios we've talked about before.
Right.
We are heading into the outer limits of criminal liability, the really messy, complex stuff, where the law starts to feel a little bit like a trap.
It really is a fascinating area. It's arguably where the legal system is at its most, well, aggressive. We're looking at how the net of culpability stretches to catch people who didn't pull the trigger.
Or didn't even plan the specific crime.
Exactly. Or in some cases, didn't even know a crime was happening at all.
Which sounds terrifying. The core question we're wrestling with today is basically, how can you be found guilty of a crime you didn't personally commit? We're talking about the intersection of conspiracy, accomplice liability, and this beast called vicarious liability.
That's it. Our mission today is to dissect the doctrines that expand liability beyond your own personal conduct. And to keep us from getting lost in the weeds, we have a roadmap.
Good, let's hear it.
We're going to start with the Pinkerton rule, which is huge for conspiracy. Then we'll look at the natural and probable consequences doctrine. We've got a bizarre case about a feigned accomplice involving a side of bacon.
I am very excited about the Bacon case.
It's a classic. That's State v. Hayes. Then we'll look at entrapment defenses in United States via Zadian. And finally, we'll end with the boardroom nightmare of vicarious liability in United States v. Dodderwijk.
Okay, let's unpack this. We'll start with the heavy hitter, conspiracy. So if I agree to help a group rob a bank, I'm the driver, let's say, does that automatically make me an accomplice to every single other crime the group commits? Like, if they decide to steal a car on the way there and I didn't know about it, am I on the hook?
Under the federal rule, the short answer is yes. This is known as the Pinkerton rule. It comes from a Supreme Court case, and it establishes a very, very broad scope of liability.
So what's the general rule?
The general rule is that a member of a conspiracy is liable for all substantive offenses committed by any of their co-conspirators.
All of them. That's huge.
As long as they meet two criteria. First, the crimes must be committed in furtherance of the conspiracy. And second, they must be reasonably foreseeable as a natural consequence of that unlawful agreement.
So I don't need to be there. I don't need to help with that specific side crime.
No, and that's the vital distinction. Evidence of direct participation in the specific crime is not necessary.
Well,
Mere membership in the conspiracy plus foreseeability imputes the liability to you. It operates on this kind of agency theory, basically. When you join a conspiracy, your partners become your agents. You are responsible for what they do.
that feels massive. And I know we have a specific case that illustrates just how far this goes. Let's analyze Pinkerton v. United States. First, what are the legally dispositive facts?
So this involves two brothers, Daniel and Walter Pinkerton. They were in the business of moonshining and tax evasion. The key twist here involves the timeline. They had this ongoing conspiracy to evade taxes. But for a significant portion of the time when these specific tax evasion acts were happening, one of the brothers, Daniel, was actually sitting in a jail cell.
Wait, he was in jail.
He was incarcerated, yes.
And what was the core legal issue?
Could Daniel, the guy locked in a cell, be convicted of the substantive tax evasion crimes his brother Walter committed on the outside solely based on the conspiracy?
Even without participating in the specific acts.
Exactly, even
Right.
when he was physically incapable of participating.
I'm guessing, based on the name of the rule, that the answer isn't good for Daniel. What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The Supreme Court applied what we now call the Pinkerton rule. It has three elements. First, was there a conspiracy and was the defendant a member? Second, was a substantive offense committed in furtherance of that conspiracy?
Okay,
And third, was that offense a reasonably foreseeable consequence of the agreement?
thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the existence of the conspiracy and his membership?
Well, the court said yes. Daniel and Walter clearly had an unlawful agreement. And here's the crucial part. Even though Daniel was locked up, the court found he had not effectively withdrawn from the conspiracy.
How do you withdraw from jail?
That's the thing. In the eyes of the law, unless you take affirmative steps to get out, like telling the police or notifying your co-conspirators that you're done, you remain a member, even from a cell.
So silence isn't withdrawal. Understood. Now, what about the second element? Was the crime in furtherance of the conspiracy?
That was the easy part. Walter's tax evasion was the direct object of their agreement. It was the whole point. So that was clearly in furtherance.
Which brings us to the third element. Foreseeability. This seems like the real sticking point.
It's the linchpin. The court reasoned that since Daniel helped plan the scheme, and he set the wheels in motion, and he never withdrew, it was reasonably foreseeable that Walter would just continue doing exactly what they planned.
So he's responsible for the natural consequences of the scheme he helped start.
That's the logic, yes.
And after analyzing all the elements, what was the court's final conclusion?
The conviction was affirmed. Membership in the conspiracy is sufficient to impute liability for substantive crimes committed by partners, provided they are foreseeable.
That is intense. I didn't do it. I was in jail, but I'm guilty.
It is extreme. And I should note, this is a controversial rule. The Model Penal Code, which is a sort of standardized guide for criminal law, actually rejects the Pinkerton rule.
Why is that?
The drafters thought it was way too broad. They argued that if you have a massive conspiracy, like a giant drug ring, a minor participant could legally be held liable for thousands of crimes they never even knew about.
But in federal court.
In federal courts, Pinkerton is still the law of the land.
That is a crucial distinction. If you're in a Pinkerton jurisdiction, pick your friends very, very wisely. Okay, let's shift gears from conspiracy to accomplice liability. This is slightly different, right? This is about aiding and abetting.
Right. Conspiracy is about the agreement. Accomplice liability is about the help.
So here's the scenario. I help a friend commit a crime. Let's call it the target crime. But then my friend goes rogue and commits a totally different crime, a non-target crime. Am I on the hook for that one too?
This brings us to the natural and probable consequences doctrine. The general rule here is that accomplice liability extends to acts of the principal that were a, quote, natural and probable consequence of the criminal scheme you encourage.
So again, it comes back to foreseeability.
Yes, but with a nasty implication. It means you can be liable for a crime requiring intent like murder based essentially on negligence. You didn't intend the murder, but you were negligent in not foreseeing that your plan could lead to it.
I think we need some examples to make this natural and probable concept stick, because probable feels subjective.
It can be. Let's look at two contrasting scenarios from the case law. First, the burglary shooting. Imagine you aid a friend in a burglary. You boost him up to a window. Inside, he encounters a homeowner and shoots them.
But I didn't want him to shoot anyone. I just wanted the TV.
It doesn't matter. Under this doctrine, you are liable for the shooting. Why? Because the law says violence is a natural and probable consequence of breaking into someone's house. You own that risk.
Okay, fair enough. Burglary is dangerous. What about something where the connection is looser?
Consider the safe versus the watchman scenario. You help a friend steal a heavy safe from an office building. But then, while your friend is inside alone, he sees the night watchman and decides, on a whim, to rob the watchman personally. Takes his wallet and watch.
Am I liable for the robbery of the watchman?
Generally, no. Courts usually say that stealing a safe doesn't naturally and probably lead to a personal robbery of a guard. It wasn't a probable consequence of the specific theft you agreed to help with. It's a deviation.
The source material also mentioned a really weird hypothetical about a gas meter.
Yes, the gas meter case. It illustrates the limit. If person A steals a gas meter, and as a result, gas escapes into the house and makes person B sick, person A is generally not liable for the physical harm to B just because they stole the meter.
Why not? The gas leak seems pretty natural if you rip a meter off the wall.
It is. But the issue is the mental state. You can't just transfer the intent to steal to cover intent to injure. You need the requisite mens rea for the harm. It shows that while we stretch liability, we don't stretch it infinitely.
Okay, speaking of mental states and intent.
Yeah.
This leads us to one of my favorite puzzles in this module, the feigned accomplice. Can you be an accomplice if the person you are helping isn't actually committing a crime?
Right?
Like, what if they are faking it?
This is a tricky area, and it comes up in sting operations. The general rule is that the guilt of the principal is ordinarily a prerequisite to accomplice liability. You can't aid a crime that doesn't happen.
Okay.
If the principal lacks the mens rea, if they are faking it, they commit no crime. And logically, the accomplice cannot be guilty of aiding a nothing.
This sounds like legal algebra. Let's analyze State v. Hayes, because the facts here are just bizarre. First, what are the legally dispositive facts?
Right. So in State v. Hayes, we have a guy named Hayes who proposes to a guy named Hill that they burglarize a general store. What Hayes doesn't know is that Hill is actually working with the owners to trap him. Hill is the feigned accomplice.
So Hill is a snitch.
Effectively, yes. So they get to the store. Hayes raises the window and boosts Hill inside. Hill, the snitch, climbs in, grabs the side of bacon, and hands it back out the window to Hayes.
And Hayes never goes in.
Hayes never actually enters the building. He's just standing outside with the bacon.
So what was the core legal issue?
Could Hayes be convicted of burglary as an accomplice to Hill when Hayes never entered the building and Hill never intended to steal?
This is a great puzzle. What rule did the court use, and what are its elements?
The court applied the rule of derivative liability. It has two simple elements. One, the principal must commit the specific crime, meaning both the act and the intent.
Actus reus and mens rea.
Correct. And two, the accomplice must aid or abet with the intent that the crime be committed.
Okay, let's do the elemental analysis. How did the court apply the first element, the principal's guilt?
Well, they looked at Hill, B the principal. B entered, so he did the act. But B had no intent to steal. He had no mens rea. He was feigning. Therefore, B committed no burglary. Element 1 fails.
So even though Hayes intended for a crime to happen, the analysis stops right there.
For accomplice liability, yes. The court looked at the second element, Hayes' aiding, but it didn't matter. Hayes had the intent and the act of aiding, but because element 1 failed, there was no principal crime, so derivative liability fails.
And what was the final conclusion?
Hayes is not guilty of burglary. You cannot aid a burglary that legally never happened. He held the bacon, but he didn't hold the liability for the burglary.
That feels like a loophole.
It is. I mean, in modern jurisdictions, they would probably nail him for attempted burglary or conspiracy. But under the strict rules of accomplice liability for the substantive crime, he gets off because his partner was a fake.
Okay, so if your partner is a fake, you might be safe. But what if your partner is real, but they have a special excuse? Let's talk about entrapment. If the principal gets off because they were entrapped by the police, does the accomplice get a free pass too?
Not necessarily. We have to distinguish between a defense that says no crime happened, like in the Bacon case, and a defense that is personal to the defendant.
Let's make this concrete. Let's analyze United States v. Azadian. What are the legally dispositive facts?
So here, Azadian is the defendant. He aided a draft board employee in soliciting bribes. The draft board employee, the principal, was clearly the one taking the bribes.
Okay.
But at her trial, she was found not guilty because she was entrapped by the government. The government induced her to do it. Azadian, however, was not entrapped.
And the core legal issue.
Can an accomplice Azadian be convicted if the principal is acquitted due to entrapment?
What rule did the court apply here? What are the elements?
They applied the rule of personal defenses. It has two main ideas. First, entrapment is a defense that shields the specific individual who was induced by the government. It's personal to them.
Okay.
And second, entrapment doesn't negate the fact that the criminal acts occurred. It just grants that one person immunity from prosecution for it.
I see the distinction. So let's do the elemental analysis. How did the court apply that first element, the personal nature of the defense?
They said the principal was entrapped, so she gets the shield. She gets immunity. It applies only to her.
And the second element, the fact that the crime still happened.
Right. The criminal act soliciting bribes still occurred. Azadian aided this act. He had criminal intent. And critically, he was not induced or entrapped by the government. He doesn't get to hide behind her personal shield.
So what was the court's final conclusion?
His conviction was affirmed. The defense of entrapment is personal. The accomplice is liable based on his own culpability. Just because your partner gets a get-out-of-jail-free card doesn't mean you do.
All right, we have one final frontier to cover, and this one scares me the most. Vicarious liability. Specifically in the corporate world. How is this different from what we've been talking about?
It is a critical shift. Everything we've discussed so far, conspiracy, accomplice, requires some level of intent or knowledge. You have to want the crime to happen, or at least agree to the scheme.
Right.
Vicarious liability dispenses with the personal act, and often it's paired with strict liability, which dispenses with the intent.
So you don't have to do it, and you don't have to mean it.
Correct. And that brings us to our final case, United States v. Dodderwyk.
This is the pharmaceutical case. Let's analyze it. What are the legally dispositive facts?
Dodderwyk was the president of a pharma company. The company shipped misbranded and adulterated drugs. This is a clear violation of the Food, Drug, and Cosmetic Act.
Now, did Dodderwyk go down to the warehouse and pack the wrong pills?
No. The facts show he had no personal involvement in this specific shipment. He probably didn't even know it was going out that day.
So he didn't do it, and he didn't know about it. So what was the legal issue?
The issue was whether the president of a corporation can be held criminally liable for the acts of his subordinates without any personal participation or knowledge.
How can they possibly justify that? What rule did the court create, And what are its elements?
The Supreme Court used the public welfare offense doctrine, and they laid out a test. First, does the statute regulate dangerous articles or public health? Second, does the statute dispense with mens rea?
So is it strict liability?
Exactly.
Yeah.
And third, does the defendant stand in a responsible relation to the public danger?
Okay, let's do the elemental analysis. How did the court apply these elements to Dodderwyk?
Well, element 1 was easy. Drug purity is a high-stakes public welfare issue.
Obviously.
For elements 2 and 3, the court sort of bundled them. They reason that because the statute imposes strict liability, no intent needed, it implies that the person standing in responsible relation to the public danger is the one on the hook.
And that's the CEO.
That's the CEO. Dodderwyk runs the company. He profits from the system. Therefore, he bears the burden when the system fails.
So if you run the company, you own the mistake,
Yeah.
even if you couldn't have prevented it. And what was the final conclusion?
The conviction was upheld. The court said the burden is placed on those who deal in dangerous commodities to ensure compliance, even vicariously. They admitted it was a hardship, but said the hardship should fall on him, not the public.
Wow. That feels incredibly harsh. I know there are critics of this.
Oh, absolutely. It's an outrageous extension of liability in the eyes of many legal scholars. Dodderwyk basically says if you deal in dangerous items, you are the insurer of public safety with your liberty as the collateral.
Remind me never to become the CEO of a pharmaceutical company.
It definitely raises the insurance premiums.
Okay, we have covered a massive amount of ground today. For the listener who needs to apply this, maybe on an exam, how do we synthesize this?
If you're looking at a fact pattern where someone is being blamed for a crime they didn't personally do, I'd suggest a liability diagnostic checklist. Just ask these questions in order.
Okay, what's step 1?
The conspiracy check. Is there an agreement? If yes, look at Pinkerton. Was the crime in furtherance and foreseeable? If yes, they are liable, assuming you're not in a model penal code state.
Step 2.
The scope check. If it's just aiding and abetting, did the principal go rogue? Apply the natural and probable consequences test. Was the new crime a foreseeable escalation? Burglary to shooting? Yes. Safe theft to personal robbery? Probably not.
Step 3.
The principal validity check. This is the Hayes-Bacon check. Did the principal actually commit a crime? If the principal was faking it or lacked intent, the accomplice usually walks on the substantive charge.
Step 4.
The defense check. Does the principal have a defense? Is it personal, like entrapment in Azadian? If so, the accomplice is still on the hook.
And finally,
The relationship check. Is this a public welfare offense? Are we dealing with drugs or dangerous items? If yes, look for Dodderwyk. The boss might be liable just for being the boss.
that is a powerful toolkit. It's scary how wide the net is, but at least now we can see the strings.
Exactly. We usually think of crime as something you do. These doctrines show that crime can also be something you are connected to. Be careful who you agree with, who you help, and what business you run.
Wise words. That's it for this deep dive. Stay out of conspiracies, don't hold the bacon, and we'll see you next time. Stay curious, everyone.